Okay.
Hi, everybody. I'm Judy, the YouTube lawyer, and with me today is Dawn DeCusto, who is ready and willing to help read. And this is a lawsuit that was filed by Charlie Adelson as a class action plaintiff against U.S. Legal Services. This is kind of an old case back from 2009. And ultimately, the federal court judge, totally dismissed the case and said, this isn't a class action, goodbye. So that was the end of that. But I thought it might be still interesting to read because it kind of gives you a taste of Charlie Adelson's litigiousness. So, how are you doing, Dawn?
I'm doing great. I'm interested in this, so I didn't realize it was actually before all of the horrible events that happened. So this is really interesting.
Yeah.
And I love the title of your show, Charlie, and the lawsuit factor or something like that. Yeah. So I invited a couple people to listen. So if they're listening, Judy, and I have an idea about how I would answer this, but what would you suggest for somebody who isn't familiar with this case? Would you suggest them to start with the Over My Dead Body podcast to get up to
Sure.
speed? Yeah,
Yeah, that as well as the 2020 special
that's right.
about was that the one called In-Laws and Outlaws, or was that the date?
Yeah, I think that's it.
Yeah.
Mhm.
Okay, yeah, there's just like so much information out there, it can be kind of overwhelming at times.
Right.
This is kind of an offshoot of the Dan Markel murder coverage because this has to do with Charlie Adelson and his whole history of always, wanting to sue everybody, get every nickel and dime he can out of every situation, and use the legal system to his own means. So we'll hear some more details about Charlie's underlying case here also. So
Awesome.
um, okay, so let's get started. Let me add that to the stream. And do you want me to start or would you like to start?
Uh, Either way.
Okay. Okay. I'll just go ahead and start, get it over with. Yeah. Okay.
Okay.
So this is a 2009 case, and ultimately the judge made his decision in 2010. And the case was called, actually, it was called Charles Adelson versus U.S. Legal Support. And they consolidated this with a couple of other class action cases because it all dealt with the same types of legal issues where the judge was going to say that you don't meet the criteria for having a class action. So it says order denying class certification and dismissing cases for lack of subject matter jurisdiction. Before the court are three motions for class certification in Adelson versus U.S. Legal Support, Inc. et al., Glenn J. Weber, PA versus Esquire Deposition Services, LLC, and Public Concepts, LLC versus Veritext Corp. In each case, the plaintiffs allege that the defendants' court reporting firms violated Florida's Deceptive and Unfair Trade Practices Act. I think you can shorten that to FDUTPA, and were unjustly enriched by a billing practice under which the defendants charged the same rate for transcript pages and index pages. Although the court has not formally consolidated these cases, because each case has overlapping legal issues, the court has frequently dealt with the cases jointly. And because the court concludes that common factual and legal issues control the certification decision, the court disposes of the motions jointly. Okay, so I won't bother reading that dense footnote.
Oh, okay.
Okay, go ahead.
For the reasons set forth below, the court declines to certify the proposed classes. Accordingly, the motions for class certification are denied, and each case is dismissed for lack of subject matter jurisdiction. Introduction. This litigation centers on the fair pricing of the word indices, which is a plural of index, right?
Indices.
Yeah. That's not a word I normally say.
Okay,
The
indices.
word indices included with the transcription. These word indices are computer generated, and their production does not require the services of a trained or licensed court reporter. Nonetheless, the defendants charge their customers the same per page amount for the computer generated indices as for the court reporter generated transcript pages. The court is mindful that it should not delve into the merits of the claim in deciding whether to certify a proposed class. For that reason, in reaching the decision below, the court does not consider whether the complaints state the meritorious claim for relief. Nonetheless, the court believes that an analysis of the nature of the plaintiff's claims is appropriate in resolving the motions for class certification. Essentially, each plaintiff's claim is premised on the assumption that there is an unquestionably true or fair price for each index page, and that the price of each index page must be lower than the price of each transcript page. Although court reporting services are somewhat regulated, the plaintiffs have pointed to no authority, in parentheses, and the court's own research has revealed none, and parentheses, supporting this proposition. Indeed, to the extent that any authority exists on fair pricing for index pages, that authority undermines the plaintiff's position. For instance, the federal judiciary's policies specifically allow court reporters to charge the same rate for transcribed and index pages. This seems so petty.
It does.
C6 Guide to Judiciary Policy, Court Reporting 520.46 in 2009. The court in parentheses, the court reporter may charge for the index page as a full page of transcript, in quotes in parentheses. And the plaintiff's contention that the more labor-intensive elements of a composite good must be more expensive than the less labor-intensive elements of the good, taken to its logical conclusion, would upend the manner in which the most ordinary commercial transactions are undertaken. Under the plaintiff's theory, for example, a fast food establishment would have to provide customers with an itemized receipt setting forth the price of each of the components of a cheeseburger. Otherwise, if the restaurant charged the same amount for the cheese and beef patty without providing such receipt, the plaintiffs would conclude that the restaurant was acting unfairly or deceptively in violation of Florida law.
In sum, if the court accepted the plaintiff's view of FDUCPA, the American public would find itself surrounded by countless examples of unfair or deceptive conduct or practices, many of which are and have been long accepted as a normal part of life. American commerce has advanced to its present robust state without a requirement that merchants supply their customers with a detailed price breakdowns and elaborate component lists. The absence of such a requirement is less evidence of a lack of insightful policymakers or lawyers than it is evidence that a failure to provide detailed pricing information is neither illegal nor immoral, unethical, oppressive, or unscrupulous. But setting aside the merits-based analysis, as the court must do when reviewing motions for class certification, several issues preclude certification of the proposed classes. Among these issues, the opposition briefs and record indicate that numerous prospective class members negotiated special rates with the court reporting firms, while others did not. Some members were repeat customers, while others had one or very few transactions, and some members reviewed invoices while others did not. These factual differences and their attendant legal implications defeat the predominance requirement. Sorry about that. I think I needed some hot tea, sorry. There are also extreme administrative difficulties with the class. One salient difficulty is that it would be an extraordinarily labor-intensive process to determine who ultimately paid for the transcript in question. Some lawyers, for example, were hired on a contingency basis and may not have passed costs on to their clients. Then, after identifying the class members, it would be virtually impossible to determine damages on a class-wide basis because, as the record demonstrates, Each class member subjectively values the index. Therefore, establishing damages where the value of the index varies from consumer to consumer would be another extraordinarily labor-intensive process. Merely determining the identity of class members and ascertaining the value that they individually attach to the indices would be such a monumental task that it would outweigh any of the potential benefits flowing from class certification. Background. A. The complaints. The complaints allege that the defendant's practices with respect to charging, overcharging, billing, and or collecting fees for multi-page computer-generated word indexes related to transcripts of depositions, hearings, or other proceedings violated FDUPA and caused the defendants to be unjustly enriched. Okay, you want to go ahead?
Oh, sorry. I'm just kind of enraptured with your reading. Okay, based on these alleged violations, the plaintiffs brought suit on behalf of all, quote, all persons and entities in Florida who or which during the 4 years prior to the filing of the lawsuits and during the pendency of these lawsuits paid for a word index for a transcript at the page per page rate charged by the defendants for transcription services, end quote. The plaintiffs contend that the defendants' index charges are unlawful because while the transcription of spoken words such as deposition, examination, and testimony requires the labor and skill of the licensed court reporter, the deposition index is generated by a computer software program. And the creation of the index, quote, does not require or involve any particular labor or skill on the part of a licensed court reporter, is not a transcription of testimony, and is not even a part of the official legal transcript of the deposition, hearing, or trial, end quote. According to the plaintiffs, the defendants acknowledge the difference based on the number of pages of spoken word they transcribe and are not based upon pages of the index attached to the particular transcript. I'm sorry, that was a quote, end quote. The plaintiffs also contend that the defendants should charge different prices for transcribed pages and index pages because the indices do not constitute a part of the transcript. The plaintiffs support this contention by citing to various definitions of transcript, including the one set forth in Black's Law Dictionary, 6th edition, which defines transcript as that which has been transcribed, commonly the record of a trial, hearing, or other proceeding as prepared by a court reporter. Again, end quote. Keep missing those. In sum, the plaintiffs contend that the defendants' billing practices are unfair or deceptive because the defendants knowingly or intentionally charged for the same per page price for transcript and index pages without disclosing this practice to their customers. B, the motions for class certification. All three motions seek certification of class consisting of all persons or entities who or which for the 4 years prior to filing of this action and during the dependency of this action, in parentheses, the class period, and parentheses, paid for a work index to a transcripts and did not do at a transcription per page rate in connection with court reporting services provided by the defendant in Florida. The class excludes counsel representing the class. And yeah, would you want to go every other paragraph? Would that?
Yeah, that might be better. Okay. Yeah, that's fine. Yeah, you don't need to read these defendant exhibit number blankety blank citations. Okay. All motions seek to certify the above class based on the defendant's practice of charging the same rate for transcript and index pages without disclosing that practice to their customers. The plaintiffs contend that the court should certify this class under Rules 23A and 23B3 of the Federal Rules of Civil Procedure.
To justify certification under Rule 23A, the plaintiffs argue that the elements of numerosity, commonality, typicality, and adequacy of representation are satisfied. The plaintiffs contend, in parentheses, and the defendants do not dispute, in parentheses, that the proposed class consists of a sufficient number of people, in parentheses, thousands, and parentheses, to justify certification. Commonality exists according to the plaintiffs because the FDUTP, I don't know how you say it,
Yeah, that's fine.
yeah, that thing, that acronym, and just enrichment claims arise out of the same billing practice, which was applied uniformly to most of the defendant's customers. To satisfy typicality, the plaintiffs argue that their claims are similar to those of the prospective class members. Finally, the plaintiffs argue that they are adequate representatives of the putative class. Yeah, because the plaintiffs' interests are aligned with those of the putative. That's a word I haven't heard. I'm thinking putative. Class members in the plaintiffs who would adequately prosecute the class action. The defendants do not dispute that the plaintiffs' attorneys are qualified to serve as class counsel.
To qualify for certification under Rule 23B3, the plaintiffs argue that the questions of law or fact common to class members predominate over questions affecting the class representatives, and there is no superior method to fairly and efficiently adjudicate the controversy. The plaintiffs argue that proof of their FDUTPA and unjust enrichment claims is generalized because those claims arise out of the defendant's uniform policies and practices of charging for word indices at per-page transcription rates. The plaintiffs further argue that individual factual questions do not exist because FDUTPA lacks a reliance requirement, and the only issue is whether the billing practices are likely to deceive a consumer acting reasonably in the same circumstances. According to the plaintiffs, damages are ascertainable using common evidence that the defendants maintain, and the fact that class members may have differing damages is insufficient to defeat class certification. Finally, the plaintiffs contend that a class action is the superior method of resolving this dispute because the four superiority elements set forth in Rule 23B3, including the, quote, likely difficulties in managing a class action, unquote, are satisfied. With respect to the difficulties in managing the class action, the plaintiffs argue that this factor is rarely sufficient to preclude certification, and the putative class members can be readily ascertained from the defendant's databases and notified by U.S. mail or publication.
1. Dr. Charles A. Adelson and Jacqueline Lorzeric versus U.S. Legal Support, Inc. and Klein, Berry, Reif, Applebaum, and Associates, Inc. In the Adelson case, Dr. Charles Adelson and Jacqueline Lorzeric sued U.S. Legal Support and its predecessor, Klein, Berry, Reif, Applebaum, and Associates, Inc. before filing their lawsuit. Adelson and Lorzeric were involved in separate lawsuits related to personal injury and wrongful death, respectively. Their attorneys in those cases used the court reporting services of U.S. Legal Support. Adelson and Lorzeric filed the present lawsuit after learning that U.S. Legal Support might have overcharged them for index pages.
In 1996, Adelson, a dentist, sued Time Warner and Sports Illustrated after he was injured in a sumo wrestling event in which he participated. In connection with his lawsuit against Time Warner and Sports Illustrated, Adelson did not order depositions, receive invoices, or pay court reporter bills. Adelson's second lawsuit was a legal malpractice action filed against the attorneys who represented him in his litigation against Time Warner and Sports Illustrated. In the malpractice case, Adelson paid deposition costs, though he did not order the depositions himself and is unaware of his attorney's agreement, if any, with U.S. legal support. The malpractice case ultimately settled, and Adelson paid the court reporting expenses out of the proceeds of his settlement. Adelson's attorney in the malpractice case negotiated and received a special rate for each index page from U.S. legal support. Adelson's attorney concluded that the court reporter expenses incurred on behalf of Adelson were, quote, reasonable and necessary, unquote, for the litigation.
The other plaintiff here, Lazarique, was a plaintiff in a wrongful death case. She employed her attorney under a contingent fee agreement. Under that agreement, her attorney was responsible for paying all expenses, including court reporter expenses. Once the lawsuit settled, the attorney was reimbursed for the expenses from the settlement proceeds. There's a footnote, but I think we're skipping those, right?
Yeah,
okay. Lazarique's arrangement with her attorney, however, was not a pure contingency fee arrangement in that she paid a retainer for several thousand, end quote, several $1,000s, end quote, so that her attorney could investigate her case. And it's unclear whether any of this retainer went toward court reporter expenses. Her attorney knew that the depositions he ordered included word indices, and he concluded that he would have determined the charge for the word indices if he compared the transcripts with the U.S. legal support's invoices.
According to U.S. legal support, the proposed class definition is overbroad because it includes customers who have paid for a word index, knowing that they were paying the same per-page rate for transcript and index pages. Vague because it does not take into account the possibility that more than one person or entity has paid for the court reporting services, and unascertainable because determining class membership under the proposed definition would require an individualized inquiry to identify the ultimate payer of U.S. legal support services.
U.S. legal support also argues that the proposed class fails to meet the requirements of Rule 23A. U.S. legal support argues that the adequacy, end quote, element is not satisfied because conflicts of interest exist among class members. One such conflict is that the class includes attorneys and clients who value the index differently. Another conflict exists because the class includes attorneys who, by passing overcharges on to their clients, may have breached ethical obligations that require attorneys to ensure that expenses are reasonable. U.S. legal support's argument is that if charging for the word index is indeed an immoral, and this is a subquote, immoral, unethical, oppressive, unscrupulous, and subquote, practice, end quote, then some clients may look to their attorneys who ordered the index for recovery, end quote. And those attorneys, quote, may respond that their expenditures were perfectly reasonable, like Mr. Adelson's attorney did at one point in his deposition, end quote.
U.S. legal support also argues that the plaintiffs cannot establish Rule 23b3 predominance because there are individualized factual and legal issues, and a class action is not the superior method of adjudicating this claim. The principal individualized legal issue involves the applicability of FDUCPA to non-Florida class members. With respect to individualized factual issues, U.S. legal support argues that the court cannot determine on a class-wide basis whether a class member was deceived. Parentheses. Some, for example, never received or paid invoices, and others expected to receive and pay for an index for their transcript. End parents. Whether the amount that U.S. legal support billed for the indices was, quote, unfair, unquote, because the perception of fairness of the charge will differ from customer to customer, and whether the billing practice caused a class member a loss. parentheses. Again, because some customers knew of the charge, felt it was reasonable, and agreed to pay for it, end parens. U.S. legal support also argues that the plaintiffs have not set forth a reasonable methodology for the generalized proof of damages. U.S. legal support makes roughly the same arguments with respect to the unjust enrichment claim. U.S. legal support finally argues that a class action is not the superior method of adjudicating this case because there are significant manageability problems given the number of individualized issues.
2. Glenn J. Weber, PA versus Esquire Deposition Services, LLC, et al. The Weber plaintiff is a law firm that employs attorney Glenn Weber. The record indicates that Weber has taken over 1,000 depositions in his career, a volume largely attributable to his previous concentration on insurance defense matters. For the past 10 years, Weber has received word indices with the transcripts he ordered. Weber, however, claims not to use these indices because he prefers to create his own. For as long as he has ordered transcripts from defendant Esquire, Weber has not complained to Esquire about its practice of including indices with his transcripts, has never personally, in parentheses, or through his support staff, and parentheses, inquired with Esquire about the indices or their cost, and has paid the invoices as submitted.
Weber's law firm's mailroom practice ensures that Weber never sees invoices related to transcripts. The record indicates that Weber's staff sends him the transcript, including index. Invoices, however, are passed along to Weber's wife, a former court reporter, who is aware of the inclusion of indices with transcripts based on her prior employment. The firm's practice is to pay all invoices, parentheses, including invoices relating to transcripts, end parens, without further inquiry, unless the invoice in question requires payment of a particularly large sum, parentheses. For example, if the invoice is for payment of an expert witness's fee, end parens.
Since filing this lawsuit, the Weber firm has continued to order depositions from Esquire without inquiring about what was included in the transcript and without asking that Esquire omit the index or charge a lesser price for the index. Weber claims that ordering these transcripts was a mistake.
Although the plaintiffs agree that the only proper class members are the ultimate payers of the charges for the index pages, Esquire contends that the proposed class is not adequately defined or ascertainable. In particular, Esquire contends that it is impossible to determine who actually paid for the transcripts in question because transcripts are typically ordered by attorneys, and the costs are either passed on to the client or absorbed, parentheses. If, for example, the attorney represented the client on a contingency basis and the attorney's client did not prevail, end parens. An additional problem with the proposed class, according to Esquire, is that class membership is fluid. For instance, an attorney who has not been reimbursed by his client may be the proper class member at one moment, but class membership will shift to his client once the attorney is reimbursed for the costs he advanced. Class membership could shift again if the court awards costs or an insurance company covers the cost of the transcript. Further, it is possible that the attorney and client will both be class members if the attorney decided to offer the client a discount or absorb some portion of the litigation expenses. The task of determining who holds the claim would require attorneys to review their records and individually determine whether they passed on the cost of the transcript to their clients or were reimbursed from another source, a huge administrative task.
Esquire also contends that the proposed class fails to meet the commonality, typicality, and predominance requirements of Rule 23. Esquire's challenge to the commonality requirement, in parentheses, as concerns issues of law, in parentheses, is based on whether FDUPTA, I don't know why I think that word is funny, whether FDUPTA applies to ultimate payers that reside outside of Florida. With respect to issues of fact, Esquire argues that individual issues predominate because there are customers who have had actual knowledge of the billing practices and nevertheless purchase transcripts with indices. Some customers have negotiated rates, and Esquire has issued many different kinds of invoices over time. Further, Esquire argues that FDUPTA requires the court to consider whether an allegedly deceptive practice is likely to mislead a consumer acting reasonably in the same circumstances. This aspect of FDUPTA would require the court to undertake an individualized examination of the prospective class members to ascertain the circumstance under which each class member purchased the transcript. Esquire also argues that there could be conflicts among class members because attorneys have an ethical obligation to ensure that the costs they pass along to clients are reasonable, and if they are passing along costs that are unfair or deceptive, the attorneys may have breached this obligation to their clients. Finally, Esquire argues that the court should not certify this class because the damages determination cannot be completed on a class-wide basis, primarily because individuals value the indices differently.
3. Public Concepts LLC versus Veritext Corp. Plaintiff Public Concepts is a political consulting firm that has been sued several times for defamation. Public Concepts claims to have paid for only one Veritext transcript, unlike the 1,000 transcripts for which the Weber firm has initially paid. As with the above described cases, Public Concepts relied on its lawyer to order transcripts. Public Concepts' lawyer concedes that he uses the word indices and finds them valuable. While he values the indices, Public Concepts' lawyer agrees that other attorneys may value the indices differently.
For many of the same reasons argued in the Adelson and Weber cases, Veritext argues that the court should not certify the proposed class. Veritext argues that existing records render it too virtually impossible to determine who ultimately paid for indices and therefore who qualifies for this class membership. Further, Veritext argues that individual issues predominate and the class action is not the superior method of adjudicating the dispute. For instance, Veritext argues that the plaintiffs will be unable to establish causation under FDUPTA on a class-wide basis because some of Veritext's customers may have known about the index and the related charge. Further, some of Veritext's clients specifically negotiated for or ordered word indices at the prescribed rate, in parentheses, including the same rate as other portions of the transcript, end parentheses, and cannot reasonably assert that they were deceived. Veritext also argues that damages cannot be proven in a class-wide basis because the value of word indices will vary from customer to customer. According to Veritext, the court should also decline to certify the class because there are significant manageability challenges, primarily because it is difficult to determine who ultimately paid for the indices and how they value the indices. Veritext also argues that the commonality, typicality, and adequacy requirements of Rule 23A are unsatisfied. With respect to commonality and typicality elements, Veritext arguments resemble those made by Esquire and U.S. Legal Support. In addition, Veritext argues that Public Concepts is not an adequate class representative because since Public Concepts have admitted to violation of Florida's election laws, it lacks the integrity necessary to fulfill the fiduciary role of a class representative.
Legal standard. To obtain class certification under Rule 23 of the Federal Rules of Civil Procedure, the plaintiffs must meet each of the requirements specified in Rule 23A and at least one of the requirements in Rule 23B. Rule 23A requires plaintiffs to demonstrate that the proposed class satisfies the prerequisites of, quote, numerosity, commonality, typicality, and adequacy of representation, unquote, citing Valley Drug Company versus Geneva Pharmaceuticals, Inc. The plaintiffs seek class certification under Rule 23B3. To certify a Rule 23B3 class, the plaintiffs must demonstrate that 1. Questions of law or fact common to class members predominate over any questions affecting only individual members, and 2. A class action is superior to other available methods for fairly and efficiently adjudicating the controversy, citing Federal Rule of Civil Procedure 23B3 and Vega versus T-Mobile USA.
End quote. Although the trial court should not determine the merits of the plaintiff's claim at the plaintiff's claim at the class certification stage, the trial court can and should consider the merits of the case to the degree necessary to determine whether the requirements of Rule 23 will be satisfied. End quote. Valley Drug, citing Valley Drug, blah, blah, blah. End quote. It is inescapable that in some cases there will be overlap between the demands of Rule 23A and B and the question of whether a plaintiff can succeed on the merits, end quote. And that's Huff versus ND Cass Company of, I'm guessing, Alabama. End quote. Thus, the principle that district courts should not evaluate the merits of plaintiff's claim should not be talismanically invoked to artificially limit a trial court's examination of the factors necessary to a reasoned determination of whether a plaintiff has met her burden of establishing each of the Rule 23 class action requirements, end quote. That's Babineau versus FedEx Corp. And other citations. Also, see also Cooper's, all that. So the class determination generally involves considerations that are enmeshed in the factual and legal issues comprising the plaintiff's cause of action. The more complex determinations require in Rule 23B3 class actions entail even greater entanglement with the merits, in parentheses, emphasis and citations omitted, end parentheses.
Finally, district courts have ample discretion in deciding whether to certify a class. An important consideration is whether the proposed class action is manageable, and this consideration is committed to the district court's discretion, particularly, quote, because district courts generally have a greater familiarity and expertise with the practical and primarily factual problems of administering a lawsuit than do the courts of appeals, unquote. Citing Andrews versus American, I don't know what that stands for, Telegraph and Telegraph, maybe?
Possibly, yeah.
Okay, go ahead.
Analysis. In this section, the court concludes that it should not certify the proposed classes because of the significant manageability concerns and because both FDUPTA and the unjust enrichment claim require the consideration of factual matters that will significantly vary from putative. I can't get that word.
Putative member to putative member.
Putative member to putative member. Further, because the court concludes that class certification is inappropriate and the court's jurisdiction was premised on minimal diversity requirements in the Class Action Fairness Action of 2005, the court dismisses these lawsuits for the lack of subject matter jurisdiction.
A. Manageability concerns. Manageability is the most salient problem with the plaintiffs' proposed classes. The plaintiffs have argued that manageability problems are de minimis because class members could be notified by publication or identified from the defendant's own records.
The problem with this argument is that it fails to account for many of the realities surrounding the ordering of court reporting services. The record in these cases demonstrates that the court reporting services are generally ordered by attorneys. In parentheses, in fact, none of the non-attorney plaintiffs before the court indicated that they personally ordered the services of a court reporter, end parentheses. As a result of this practice, the defendant's records only reveal the names of the attorneys who ordered their services without regard to who ultimately bore the cost of the defendant's services, that is, the class members. In many cases, whether the costs of the court reporting services are passed to the attorney's clients depends on the fee agreement between the attorney and client. Some attorneys represent their clients on a contingency fee basis. This may mean that the attorney absorbs all costs unless his client prevails. If the client prevails, then the attorney deducts the cost from the settlement proceedings. Proceeds. Jeez, what's wrong with me? In many other cases, however, clients hire attorneys under engagement agreements that require the client to periodically reimburse the attorney for any costs, including the cost of court reporting services incurred in connection with the client's case. Because of the varying fee agreements, it is impossible to ascertain the ultimate payer without requiring all the defendant's customers to produce their accounting records so that the court or an appointed administrator can determine whether the costs were absorbed by the attorney or client. Adding to this task is the fact that costs may ultimately be absorbed by the losing party if the court enters an order shifting costs or an insurer pays the costs.
Even after undertaking the Herculean task of determining the ultimate payer, numerous manageability problems remain. For instance, some attorneys may offer their client a discount on court reporting expenses. This means that it is possible that on some transactions, both the attorney and his client will be the ultimate payers. A further problem is that class membership is fluid. Attorneys will be class members until their clients reimburse them for the court reporting costs, either through settlement proceeds or after paying their attorney's invoice. This complication would require the court or its appointed administrator to constantly inquire whether the previously identified class member still has a claim.
Further, because of the law attendant to FDEPTA is unjust enrichment claims, whether an individual has a claim largely depends on individualized factors. For instance, some class members have negotiated special rates with the court reporting firms, and in some instances, index charges have been a subject of the negotiation. As discussed below, some law firms have not only agreed to, but insist on paying the same per-page rate for the transcript and index pages. And other law firms likely have other negotiated agreements. In fact, the plaintiff's law firm, Bose, Schiller, and Flexner, LLP, has secured an agreement with one of the defendants under which the firm pays nothing for word indices. Bose Schiller's agreement with that court reporting firm is highly negotiated, as reflected in the detailed 5-page court reporter agreement. This agreement includes several exhibits, one of which is a table setting forth the agreed rates in different localities. While Bose Schiller has conceded that it is not a class member, one would not know that without either its concession or a thorough examination of the defendant's records. This problem would exist with other law firms that have negotiated special rates. And where rates have been negotiated, individualized legal issues will prevail because Florida law is very protective of parties' rights to contract and generally refuses to rescue firms or individuals from purportedly bad bargains. See Gainesville Healthcare Center, Inc. versus Weston. In parentheses, quote, double quote, actually, people should be able to contract on their own terms without the indulgence of paternalism by courts and the alleviation of one side or another from the effects of a bad bargain. Also, they should be permitted to enter into contracts that actually may be unreasonable or which may lead to hardship on one side. It is only where it turns out that one side or the other is to be penalized by the enforcement of the terms of contract so unconscionable that no decent, fair-minded person would view the ensuing result without being possessed of a profound sense of injustice, that equity would deny it the use of its good offices in the enforcement of such unconscious ability, end quote. Quoting 14, Samuel Williston, A Treatise on the Law of Contracts.
Okay. The Weber case has yielded several examples of how individualized inquiry reveals relevant information about a class member that may preclude the putative member from class membership. Weber, for instance, has an office management structure that leaves him unaware of how much vendors have charged him for their services. Further, Weber has continued to order transcripts from Esquire even after filing this lawsuit. In addition, Weber's wife, an employee of his law firm, has experience as a court reporter and knowledge of court reporting firms' business practices. And finally, Weber is an experienced user of court reporting services, having ordered more than 1,000 transcripts in his career. These peculiarities surrounding Weber's law practice affect the strength of his claim against Esquire by affording Esquire with a series of defenses, e.g., estoppel or ratification, that may not apply on a class-wide basis. But without deposing Weber, his wife, and other firm employees, it would have been impossible to note that those peculiarities existed. As U.S. Legal Support's attorney pointed out at oral argument, the defendants have been able to present a wealth of information about the Weber firm, its experience, practices, and employees, because that firm is the lead plaintiff in the case against Esquire, and as a result, the Weber firm has been scrutinized through the discovery process. The Weber firm, however, has also used the services of U.S. Legal Support and therefore is a prospective member of that class. In this way, the discovery of the special circumstances surrounding Weber not only preclude him from serving as the lead plaintiff, but may also preclude him from membership in at least one of the other proposed classes. It would be impractical, if not virtually impossible, to conduct the same level of discovery for every putative class member. Yet, as Weber's situation confirms, such detailed discovery would be necessary to give the defendants a fair chance to defend against or avoid paying illegitimate claims.
In short, certifying this class would result in a huge and unreasonably expensive and time-consuming undertaking to determine individualized circumstances that would burden the court, defendants, and third parties without providing a countervailing benefit that would justify such an expenditure of money and time. Therefore, after reviewing the record, the court finds as a factual matter that individualized issues of fact and law predominate, and if certified, the proposed classes would present unwarranted manageability problems to the court. Accordingly, for this reason and those below, the court declines to certify the proposed classes.
B. The FDUPA claim. FDUPA outlaws, quote, unfair methods of competition, unconscionable acts or practices, and unfair or deceptive acts or practices in the conduct of any trade or commerce, unquote, Florida Statute Section 501.204, subsection 1. To establish an actionable violation of the FDUPA, a plaintiff must demonstrate a deceptive act or unfair practice, causation, and actual damages, citing City First Mortgage Corp. Versus Barton, 2008 case.
The legislator mandated that in construing 501.204 sub 1, courts should give, quote, due consideration and great weight, end quote, to the, quote, interpretations of the Federal Trade Commission and the federal courts relating to Section 5A1 of the Federal Trade Commission Act 15 U.S.C. sub 4A1 as of July 2006, end quote. Florida Statute F5012042. In addition, the plaintiffs seek relief under Florida Statute 501.211, which authorizes redress for individuals who have been aggrieved or suffered a loss as a result of, quote, violation of this part, end quote. Quote, violation of this part is, end quote, is a defined term that means any violation of this act or rules adopted under this act and may be based on the following as of July 1st, 2006. A, any rules promulgated pursuant to the FTC Act 15 USC subsection 41. I think that's what that means. B, the standards of unfairness and deception set forth and interpreted by the Federal Trade Commission or the federal courts. And C, any law, statute, regulation, or ordinance which prescribes unfair methods of competition or unfair, deceptive, or unconscionable acts or practices. And that is Florida Statute 501.203, subsection 3.
Okay. FDUP closely resembles Section 45A1 of the FTC Act. And the quote is unfair methods of competition in or affecting commerce and unfair or deceptive acts or practices in or affecting commerce are hereby declared unlawful, unquote. The FTC Act empowers the Federal Trade Commission to regulate acts or practices that may violate Section 45A1.
1 is the practice of charging the same per page rate for transcript and index pages an unfair practice under FDUPTA. The FTC initially defined, quote, unfair, end quote, by regulation. Eventually, Congress incorporated the FTC's definition of unfair into the FTC Act. Under 15 USC 45, and the FTC may not, quote, declare unlawful an act or practice on the grounds that such act or practice is unfair unless the act or practice causes or is likely to cause substantial injury to consumers, which is not reasonably avoidable by consumers themselves and not outweighed by countervailing benefits to consumers or competition, end quote. Each of these considerations counsels against the certification of the proposed class.
The plaintiffs are unable to show on a class-wide basis that the alleged injury was not, quote, reasonably avoidable, unquote. Some lawyers and other users of court reporting services, particularly those who are fairly sophisticated, parentheses, or at least experienced, end parentheses, users of such services, could reasonably avoid the index charges by simply relying on their experience and requesting that the court reporting firms omit, parentheses, or charge a different per page rate for, end parentheses, the indices from any transcripts they order. A class definition that includes experienced and novice users of court reporting services necessarily includes those with differing abilities to reasonably avoid the allegedly unfair charge. For example, contrast a novice user similar to public concepts with a highly experienced user like Attorney Weber. One would have no idea, or at best a minimal idea, what to expect after ordering the services of a court reporter. The other would likely have developed knowledge and preferences as to court reporting firm, format of transcript, pricing, etc. In the latter category, the plaintiffs either knew or should have known that indices were included in and charged as part of the transcripts. This circumstance may also undermine the named plaintiffs' inadequacy to serve as class representatives, Weber being a good example. Further, individualized inquiry is necessary to determine whether the index charges were reasonably known and avoidable. This is because the court reporting firms delivered invoices specifying the per-page rate and the total charge, which invoices reflect and could have been used to easily discover that the charge for index pages was the same as the charge for other pages. Finally, the record in each case indicates that some class members negotiated special rates with the defendants. Those class members who negotiated special rates likely had an additional opportunity to avoid or reduce index charges.
Ouch. In addition, the quote countervailing benefits to users end quote factor counsels against class certification. The potential value of indices to users varies greatly. The usefulness and therefore the value of indices depends in part on the length of the transcript in question. For instance, an index may be extremely valuable to an attorney reviewing a deposition or hearing transcript that is very lengthy. On the other hand, the value of the index may be comparatively small if the transcript in question is relatively short. In parentheses, example, the transcript of records custodian deposition, end parentheses. The proposed class definition does not and could not reasonably distinguish between these two types of class members. Yet, those putative class members who received indices for very lengthy proceedings have received a countervailing benefit, such as the practice could not be considered unfair. Further, the value that the attorneys place on the word indices is highly subjective and variable. Some lawyers, for example, Weber, in parentheses, for example, Weber, and parentheses, place little or no value on word indices and refuse to use them, while other lawyers consider them a very valuable part of the transcript. And there is a footnote. Should I read the footnote?
Oh, no, you can skip it.
Okay. The record supports the subjective nature of the indices value. When one large law firm, Whale, Gottschall, and Mange LLP, solicited bids from court reporters, it included among the specifications distributed to the potential bidders requirement that, quote, all transcripts shall contain the back of a transcript word index, in parentheses with page references and parentheses, for all keywords and phrases, end quote. See memorandum in opposition to certification, in parentheses Veritex, and parentheses Exhibit 1 at page 4.3. Therefore, unlike Weber, the Weil Gottschall firm obviously values word indices as parts of transcripts. The plaintiff's expert, William Chandler, after initially opening as a part of his damages analysis that the indices have no value, acknowledged that word indices have some value to some individuals and a lesser degree of value, in parentheses, or no value, and parentheses, to others. In his initial written expert report, Chandler's claimed that, quote, no class members benefited from the charge per paid transcription rate for pages that did not involve transcription services, end quote. See report of William Chandler, and parentheses, Veritex case, and parentheses at paragraph 29. But his deposition testimony supports the fairly obvious conclusion that word indices have a subjective value depending on the user and the circumstances. Question, and I think they're quoting, question, but would you agree that for some people the word index would have had a value? Answer, in some cases it could. And this is from the plaintiff's attorney's objection to form. Answer, in some cases it could, in other cases it may not. Deposition of William Chandler at 86 14 through 19, another exchange, ironic because of the nature of the plaintiff's attorney's objection, further supports the notion that damages cannot be calculated on a class-wide basis. Question, do you have any sense of what the market value of the word index is? And plaintiff's attorney, objection to form, beyond the scope of his report, calls for speculation and vague. The witness, no. I think if I indicated in my report and testimony that, if it is a necessary component of the damages, it depends on I've not even been retained to calculate the damages, but assuming that I am, that would be one of the issues I would look into.
Do you want me to read?
Oh, I can finish it. Okay, I was just looking. It wasn't okay. ID at 172. This is a reference to the deposition, I guess.
Yeah, the page and the line number.
All that. All those numbers. I look at numbers and I just go, and that is precisely the problem with damages in these cases. They are speculative and contingent on numerous individualized factors. Public concepts attorney in the underlying defamation case is concisely summarized at the point in this deposition when he testified that, quote, different attorneys have different opinions about the value of word index, and I believe I also testified that I use them, end quote, because word indices, quote, save the client money in the sense that if I spent more time with the transcript to find the materials I was looking for, I would have to bill the client for that, end quote. See expert report of Bradley J. Pinn, and parentheses, submitted in Veritex, end parentheses, at 15 through 16, quoting deposition of L. Martin Reeder, Jr. Despite the obvious and significant differences in the valuing of indices, the proposed classes include customers who have received both great and little benefit from the word indices, and determining how each valued the indices would require an exhaustive, individualized inquiry.
Further, unfair practices must cause, quote, substantial injury, unquote, to be actionable. And in these cases, the proposed definition includes firms and individuals who have suffered no injury. As indicated above, different attorneys value the word indices differently. Those attorneys, or the ultimate payers, who value word indices would be uninjured, but the proposed definition would nevertheless include them as class members.
Even if the court applied the more malleable tests set forth in the Beacon property case, the court would conclude that it should not certify the proposed classes. Under that test, the plaintiffs must show both that the defendant's practices violate established public policy and are, quote, immoral, unethical, oppressive, unscrupulous, or substantially injurious to consumers, end quote. The plaintiffs could not prove either factor in a class-wide basis.
As noted earlier in this order, there is no established public policy on what constitutes fair pricing for word indices. It is telling, however, that the federal judiciary has adopted guidelines for its own court reporters that specifically allow the same per-page rate for transcript and index pages. See 6, Guide to Judiciary Policy, Court Reporting, Section 520.46 from 2009. There's a quote from it. The court reporter may charge for the index page as a full page of the transcript, unquote. This district's internet website posts a schedule setting forth the per-page fees that its court reporters may charge for transcripts without drawing a distinction between appropriate fees for index and non-index pages. See maximum transcript rates per page for all parties, June 2009 revision. In fact, the record in opposition to the motion for certification in the Weber case includes the transcript with word index of a joint hearing held early on in these cases. Attached to the transcript is an invoice from the court's official reporter for $116.58 for a 29-page transcript, priced at $4.02 per page. Notably, the invoice does not distinguish between index and other pages. In other words, the invoice charges for 29 pages of transcript without distinguishing between transcript and index pages. The hearing itself, that is, the exchanges between the court and counsel, is captured in 20 pages of transcript. The remainder of the transcript consists of a cover page, 1 page, appearance pages, 2 pages, certification page, 1 page, and index pages, 5 pages. By comparing the transcript to the invoice, one is able to easily ascertain that the court's reporter charged the same amount for transcript and index pages. And when the New York Office of the Attorney General solicited bids for court reporting services. The request for proposals specified that the selected firms would provide a Word index with a transcript. The bid form puts transcript and index charges in a single price category, thereby requiring that all bidders quote the same price for all pages. See memorandum in opposition to certification, very text. Exhibit K at 1020. That the court's official reporters and the New York Attorney General's office have the same pricing and billing practice as the defendant court reporters tends to show that there is no established public policy prohibiting the conduct that the plaintiffs decry.
The court is unaware of any authority or logic indicating that the defendant's billing practice is, quote, immoral, unethical, oppressive, or unscrupulous, end quote. In parentheses, the court addressed the substantial injury factor earlier in this order, end parentheses. The record in the case establishes the opposite. As noted below, some users of court reporting services have even considered it a bargain to pay the same price for transcript and index pages. While the court doubts that the practice in question is, quote, immoral, unethical, oppressive, or unscrupulous, end quote, under any circumstance, under the most permissive possible application of that standard, the court would conclude that whether the practice is immoral, unethical, oppressive, or unscrupulous depends on the individual experience or sophistication of the user. As discussed in further detail below, such a standard could not be appropriately applied on a class-wide basis.
For these reasons, the court concludes that the plaintiffs cannot show on a class-wide basis that the practice of charging the same per-page rate for transcript and index pages is an unfair practice under FDUPA. Okay. So Dawn, do you agree that this is like getting kind of boring and people have left the live stream already?
It goes, I know, it goes on. Well, it's just wild that he would sue over something like, I mean, this is just, I'm reading it and just like shaking my head the whole time. It's
crazy. You're thinking like, what a waste of judicial resources, to file a lawsuit. I mean, I thought it was funny at the beginning that you catch how the judge was saying this is similar to complaining at a fast food restaurant that, hey, how come the cheese and the hamburger meat are charged the same amount? I want to have it broken down as to, how much each little piece in the hamburger costs because I don't want to pay certain things.
That was an excellent illustration. And then, but as you read through it, the thing about these things is you've got to kind of read through it a little bit to find out, was there some kind of merit there? But I mean, whether somebody likes an index with their transcripts or doesn't is personal preference, basically what it comes down to. And I mean, I personally would like an index. I mean, that makes sense. Yeah. It makes sense.
Yeah, that's something that you're used to because, I wouldn't say I've done 1,000 depositions like that attorney Weber that was mentioned in this decision. But, we always have an index and it's always good to have, even though I might not actually use it. But just as one of the other attorneys deposed said in here, you'd rather have an index so you can quickly look up stuff in the deposition transcript rather than billing your client even more money because you have to dig through 400 pages trying to find a key word or a phrase that you're looking for. So, I mean, it's kind of like, this is stupid, because I'm also thinking, well, what about like you go to a fast food place and they gave you a kid's toy or they gave you extra ketchup and then you get mad because, you feel like you shouldn't have had to pay for the extra straws or ketchup or the kid's toy or whatever.
Yeah.
Can you imagine it if this kind of lawsuit could go through as a class action, then any retailer or somebody selling any sort of service or product, could potentially get targeted.
Right. The class action aspect of it too is just like, it's be one thing to sue one attorney over something like this. But I mean, come on, we're talking about a couple of dollars here. We're not talking about $1 million in the cost of these extra pages. The other thing I kind of appreciate about this, even though it was kind of long and laborious, is, how a lawyer and how the courts and the lawyers at the courts have to really justify everything and very thoroughly. And whether it's something frivolous like this or something like a murder case, I mean, it all has to be really technically laid out
Mhm.
without a question of doubt as to why they are ruling or deciding in a certain way or another. So I appreciated that. But yeah, that's a lot. That's a lot.
Mhm.
I mean, that's crazy to sue for something that, especially on a class basis, for something that trivial.
Yeah, exactly. And, I thought it was really funny to hear the background of things because I know True Lifestyles has already mentioned this in the past about his sumo wrestling lawsuit
I
where he
know.
got injured in this event that was held probably at his college campus when he was about 19 or
Oh, okay.
so he hurt his wrist and then he decided to sue Sports Illustrated and Time Warner because he hurt his wrist. And then later he sued the attorney that represented him too. So it's just ridiculous. And then you want to also sue the court reporting company because you didn't like having to pay an extra, maybe like $8 or
Right.
$12 or something for the index.
Yeah, the sumi, I forgot about the sumi. That was like way in the beginning. I mean, who does that? You go, you participate. You should be signing off on. I would think they would have signed off on any kind of um, responsibility of the
Like
school
a
or whoever.
waiver.
Yeah, you would
Yeah,
think so.
I think they forgot to make Charlie sign the waiver because they talked about this recently on Surviving the Survivor,
Ah,
also the interview with Fancy Fiction and Karen Cyphers. Yeah, so oops, somebody running the sumo wrestling event forgot to make sure that Charlie signed the waiver before he was allowed to participate in the thing.
of all the people to forget to make sign, maybe he
Yeah,
didn't. Maybe he did it on purpose. Yeah, that's crazy.
yeah, who knows?
Whoop. Hello, hi everyone. I lost Judy. Well, I think we lost Judy. I'm not gonna log out because I don't want her to not be able to say goodbye. So, and let me look at the comments.
Are you
Stella Bella. There you are.
sorry, I was hitting the wrong tab and my computer screen froze up. Yeah, but I do really appreciate everybody being there. And just for fun, I just thought it would be funny to include something about Charlie and the Chocolate Factory, if you don't mind. Do you need to go?
One of my favorite movies. No, that's fine.
Oh, okay. Yeah. So I mean, it does remind me about this wacky, crazy kids movie. Just the fact that Charlie Adelson's life just seems so wacky and screwy and goofy and bizarre, much like the whole Charlie and the Chocolate Factory book. I mean, I read the book ages ago when I was probably like in third grade. So it's been a long time. Yeah,
Yeah.
but let's take a look at some of these quotes that I thought were slightly related or kind of funny to apply to Charlie's situation. So, of course, to those who don't know about Charlie and the Chocolate Factory, it was a book written um, way back when. Well, the first film came out in 1971, so I don't know when the book actually came out, but it's about this poor kid named Charlie who wins a contest to be able to go to Willy Wonka's chocolate factory with a few other kids. Okay, so the first funny quote from this website, it says, "The kids who are going to find the golden tickets are the ones who can afford to buy bars of chocolate every day. Our Charlie only gets one a year. There isn't a hope," says Grandpa George. But see, can you imagine, like, if this happened with the Adelson family, they would probably buy up every single chocolate bar in every grocery store around the area that they could get their hands on. Just so
God,
Charlie
yes.
could get that ticket, or maybe they would, find a printing press where they could, print the winning ticket and forge it so that he would get to win. So, okay, we still have some more bots that think that everybody
I
in the
just
chat
saw
box
that. Yeah.
wants to be on a best adult dating site, so sorry
Yeah, we
about
have
that.
to report those guys. Mhm.
Yeah. Okay, and then okay, here's some more funny quotes that I thought. Okay, "Anything to eat?" cried Charlie, laughing. "Oh, you just wait and see." Okay, because that kind of like illuminates Charlie Adelson's like selfish kind of sadistic temperament.
I love
Okay.
this. This is so fun.
Yeah, this is from a website called kidadl.com, KIDADL.com. And okay, so number 14, this is funny. But there was one other thing that the grown-ups also knew, and it was this, that however small the chance might be of striking lucky, the chance is there. The chance had to be there. Okay. So that makes me think of, Charlie's hope that maybe he will be found not guilty and get to go free and get back to his
Gotcha.
Maine
I like
lobsters and loose women and Ferraris and go-karts.
Maine lobster.
Okay. Number 15. I shouldn't like to lose any of you in this state in the proceedings, says Willy Wonka. So that would be funny because I'm sure Rashbaum and Kate Myers do not want to lose at this state in the proceedings.
Oh,
Okay, how about this quote? Number 16, for who could hate or bear a grudge against a lovely bit of fudge? Says the Oompa Loompas. Okay. I just thought that was funny. Okay, another quote, number 17. I think that furnace is only lit every other day, so they have a good sporting chance, haven't they? Says Willy Wonka. Okay. So that has to do with, Charlie's sporting chance of getting out of jail and avoiding a conviction.
there's always a chance.
Yeah. Okay. Just a few more. I just thought it's kind of funny for anyone that's a fan of Willy Wonka and Charlie and the Chocolate Factory. Okay. Number 22. Mr. Wonka, don't forget what happened to the man who suddenly got everything he wanted. Charlie Bucket, what happened? Mr. Wonka, he lived happily ever after. Okay.
Aw.
Yeah. And so that's sad because, you feel like Charlie had everything he could ever want, right? Like up until he decided to allegedly plot the murder and help in conspiring to murder Dan Markel. He could have lived
Yeah.
happily ever after.
Yeah.
Okay. Number
I think
23.
Wendy would have been like that blueberry girl that blew up.
Yeah, that's right. That's right. What happened with that girl in the story? Was she too greedy or something? And Viola?
Yeah, she just and he said, "Don't have too many blueberries because you know what's gonna happen." But yeah, another one of those privileged, undisciplined, and that's kind of the thing I got out of it. Then she
Yeah, that's right. Yeah, so that's why it's funny to look at these quotes from Charlie and the
It's
Chocolate
great.
Factory. I'm almost done though.
Great.
Okay, number 24. I am very proud of my square candies that look round, said Willy Wonka. Okay, so this has to do with being delusional, as some of the
Mhm.
characters like Sigfredo and Katie seemed quite delusional. They would look at square
Mhm.
candies and think that they are round, and that's how they wound up getting convicted. Okay,
Yeah.
number 26. If you want to view paradise, simply look around and view it, says Willy Wonka. So that sounds nice because I think that part of southern Florida where they lived was pretty beautiful and scenic.
Right. Right.
Okay, number 28. I've heard uh, tell that what you imagine sometimes comes true. Okay, says Grandpa Joe. Okay, so Grandpa Joe is, I guess, talking to Charlie and telling him to, imagine some good stuff and then maybe it will come true. Okay, so
Right.
hopefully that will happen in terms of justice for Dan Markel and his family. Number 29. Did you guys know that chocolate contains a property that triggers the release of endorphins? Gives one the feeling of being in love, says Willy Wonka. Okay. Yeah. But I don't know if Charlie ever was really in love with anyone besides himself. So, number 30. Whipped cream isn't whipped cream at all if it hasn't been whipped with whips. Just like poached eggs isn't poached eggs unless it's been stolen in the dead of the night. Okay. So I just thought that was like a weird, funny quote.
I don't remember that one. That's a crazy one.
Yeah, so it's been a while. So anyway, any parting words about how you feel about Charlie Adelson or the Dan Markel case?
I mean, the Dan Markel case in general, we've got 2 more named co-conspirators. So I'm just really looking forward to the entirety of everyone who was involved to be brought to justice, to make their appearance at least. And I hope that there aren't any, with this reading this crazy frivolous. I wonder if he was ever charged with. Can't you get charged with frivolous
No, not really.
wasting
I
your
mean,
time?
granted, he did have a very well-known law firm that was representing him, because I remember Boyce Schiller, they became known, at least to me, because David Boies represented Microsoft in the whole
Oh,
antitrust
yeah.
type of litigation. Yeah, so, I guess he came up with the idea, or I mean, usually he would be the one that would have to approach a law firm to try to shop around this idea of doing a class
Right.
action lawsuit.
Yeah. True. True. Well, you
Yeah.
wonder. Yeah. Well, so, and I keep wondering about the lawyers that he has right now defending him in criminal court, because they are not experienced defense attorneys. They're white collar crime attorneys in general, and I'm just wondering if they're going to go on some kind of technicality, or I don't know. It's just kind of weird that he has those attorneys, and then the only thing I can think of is that because Dan Markel was such a respected law professor and respected around the legal world, that maybe he couldn't find a defense attorney that would represent him. I'm perplexed as to why he has, not that Rosenbaum isn't
Or
going to do a great
Rashbaum.
job, or
Yeah.
Rushbaum, yeah,
Mhm.
isn't going to do a great job. I kind of liked him. I liked his energy in court and all that, but I just wonder why he doesn't have a more expert criminal defense attorney.
Mhm.
Yeah.
Yeah, and isn't it kind of funny or strange, like, why did they need to get defense attorneys from Miami? There's gotta be some really great criminal defense attorneys closer around Tallahassee, you would think, but maybe some people from that Miami area have that kind of feeling that, everything they have is better than what people up in the north part of Florida have.
I mean, it could be, but maybe it's just like I was thinking, the legal world doesn't want to get involved in, or doesn't want to defend him against this because of the actual crime and who he killed.
Yeah, exactly, like, maybe they have some
Allegedly.
sort of moral compass that says, "I don't wanna represent this guy, I think he did it." Yeah,
Right,
yeah,
right.
could
Yeah.
be, yeah. Yeah, and of course, we have no idea why the previous attorney ended up no longer representing Charlie, so,
Yeah, it'll be interesting when it all comes out. So, do you
yeah.
think there's anything, and I've kind of been off the grid for a couple weeks, but do you think there's anything um to him pulling those motions, or is that just
Mm. No, I didn't really think that it was, like, some breaking news that there was a plea bargain. Yeah.
right?
Yeah, because as mentor lawyer explained, it could have been that the jail people at jail, the administration did finally comply with
Resolve. Okay.
whatever, Charlie's attorneys wanted to get more access with
Mhm.
Charlie, or to be able to, help Charlie decipher and weed through and have access to all the information to help his attorneys, so it was no longer necessary to even
Yeah.
have that kind of motion. Yeah.
Yeah.
So,
Okay.
but it just goes to show how obsessed some people like we are about the case, that any little thing, it's like, "Ooh, ooh, something's happening in the case and what's going
Yeah.
on," and everybody's all stirred up and wanting to figure out, what could it mean? Yeah.
Yeah.
Well,
Yeah.
Harley had a question. Yeah, so it wasn't a motion to dismiss, but basically the court said that it didn't satisfy um, the criteria for being a class action for either Charlie's case or the two other similar lawsuits that were pending before the court then. Yeah, so just kind of a dumb case that wasted the judicial resources, and I'm sure it wasted his attorney's times, because they probably were not getting paid by the hour to do that, thinking that they might have a you know big
Wow.
jackpot class action case coming up. Yeah.
Huh.
So,
Hmm.
yeah. Oh, this is funny. Screaming Toad says, if the Adelsons made chocolate bars, they would only pretend to be kosher. Yeah, that's right. They'll sell it to people and say it's kosher, and then pull the rug from underneath them
Find
and
out
say,
it's
"Ha
not. Yeah.
ha! It was kosher. It was supposed to be kosher like light, or what was it, like kosher light, or similar to kosher." Of course, you're like.
Yeah.
Yeah.
Yeah, that's one of those things. It either is or isn't, and they should know better.
Yeah. Yeah, exactly. Well, thank you so much, Dawn. I'm sorry it turned out to be kind of boring. People
And
were
I
leaving.
apologize. I didn't read it through ahead of time. I didn't notice the attachment until like 10 minutes before we went on, and I was like, "Oh, I should have read this through." So I stumbled over a couple of words,
Yeah,
but
that's okay. I mean, a lot of times I don't have time to read through the whole entire thing before I'm just like,
yeah.
"Oh, it'll be more fun to read it live, and I'll dig through it
Yeah.
then." Yeah, that's a
Hi,
lot more
Tony.
fun. Yeah, okay, well, thank you so much for your time and everything. I hope you have a good day, and I gotta get back to work as usual.
Yeah, me
So,
too. Bye,
um,
everyone.
bye,
You're welcome
everybody.
to, of course. Bye for now.
Okay, see you guys on Friday night for another live stream. Thank you. Bye.
Bye.